This is The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to educate, inform, and help you to decide how to help yourself, your family, and your business when it comes to law matters. A better understanding of the law puts you in a better position to decide how to protect them all. And hopefully, as we say, our goal is to help you achieve the best possible results while saving time and money. Always, and once again, we want to welcome Attorney David Bizarre from the Bizarre & Associates Law Firm in East Providence, who continues to weigh in on the topics that we cover. And today, healthcare, POA, power of attorney, and living wills. We've covered those topics in the past, and we've covered them in general. Turns out we've been asked if we would cover some of those topics in a little more detail, so we will. So what's in those documents? What do you need to consider? Do you really need a lawyer? So from the process in general and the details, and even some of the legalese, we'll see if we can tackle some of the questions that have been posed here, and you'll have a better understanding of how to handle some of these issues. And even when you deal with a lawyer, should you decide to do that, hopefully you'll be better equipped. So let's go to it, David. Healthcare power of attorney, living wills, we've touched on them both. What are they in general before we do the deeper dive?
Okay, so in general, the living will was a document that existed before we had healthcare powers of attorney or healthcare proxies. And oftentimes when somebody goes to a medical provider or a hospital in particular, they're asked, do you have a living will? And it's because that's what they were always used to seeing. And the living will was a directive to, however you set it up or phrase it, but basically directing the doctor not to resuscitate you or keep you alive if, in their opinion, there was no chance of recovery. Oftentimes when we draft a living will, we'll say, in the opinion of my treating doctor and an independent doctor, so two doctors, if there's no chance of recovery, don't resuscitate me. The power of attorney or healthcare proxy is appointing somebody to make decisions for you if you're not able to make them for yourself.
So if you are the person who has or is about to create the healthcare power of attorney, you're called the principal, the person you select is called the agent. What kinds of things should you consider when you're trying to decide who should be your healthcare POA? Obviously, not everybody has a doctor or nurse next of kin, and does that necessarily mean that that's who it should be. So what kind of things go into those considerations, David?
Well, picking the agent or backup agents is probably the most important decision as to what goes into the healthcare power of attorney. And the consideration should be a few things, but first of all, what is it that you're going to want? And oftentimes people want information in the healthcare power of attorney that gives direction to their agent, and usually it says that if there's no chance of recovery, don't keep me alive artificially. In fact, keep me pain-free, give me comfort measures only, even if it's going to shorten my life by a little bit of time, as long as I'm comfortable. So the first consideration is picking somebody who's going to follow your direction. And oftentimes, I'll have people in and we go through, and part of what we like to do is understand who the players are and who could be the agents and what their mindsets are and will they follow those directions. And sometimes there are folks who will come in and say, well, I want one of my children to do it, but this child won't do that. They won't pull the plug. This one will. So I want that one first. And those are some of the considerations. The other consideration would be to have somebody who has an understanding of health, medicine, and those types of things, so that when they're given the information to make a decision on your medical condition, they'll understand what's being talked about.
Does physical proximity matter? So maybe daughter X or niece Y is capable, has the capacity, will follow directions, but they're miles, states away. Does that preclude them from being a good healthcare selected POA?
So maybe at one time, but in today's world, not so much, I don't think, because there's a couple of things. The first thing is one of the pieces of information that goes into the healthcare power of attorney is usually a cell phone number. It asks for the person's name and oftentimes address and telephone number. But I always, at this point in time, say, I'm not sure exactly why we need the address, because it's not as if they're going to write you a letter and say, we need to make an immediate decision about the person who gave you power of attorney. Get back to us as soon as you can. No, they're going to call. So since they can call, I believe that, I do think it's best to have someone who can be present, but if your best choice is someone who has a cell phone and can be reached, then I would do that person first.
Okay, so if someone isn't with an attorney and is going to make that decision on their own and maybe go to an attorney or not go to an attorney, maybe they're just going to go to their doctor, they can go to their doctor with that information, can they? Or can they not do that? So they have to go to an attorney to have a healthcare POA in effect?
I don't think a doctor's office is going to help you fill one out.
But if you have the information, I want John Jones, do they keep that on file when you're visiting with your doctor?
I think they're going to want to have an properly executed document that is presented to them.
So that we're going to go there in a second. So if you are with someone at the outset when they're beginning to get those papers in order and those affairs in order, would it be one of the things that you would start to do, start to interview someone or the someones who are candidates or likely POAs, or would you just say, let's talk about, John, let's talk about who you are wanting to select and discuss this, or would you bring them into your office?
So when somebody comes to see me, oftentimes it's for an estate plan. And this is one aspect of the estate plan, whether it's a trust plan or a will plan. The healthcare documents are very important. And we will talk, just like we talk about who's going to be your trustee, who's going to be the executor of your will, what are the talents that are required for that, what should you be looking for in somebody. We do the same thing when we talk about who your agent's going to be. And so we usually will create a family tree, a list of friends, talk about their strengths and weaknesses, who do you want, why do you want that person, and vet it out with our client to make sure they're picking the correct person.
And you are first going to be talking about what are your plans, what do you want for yourself, and who you might select. So once that's done, the person is going to ask and hopefully get the approval, yes, I'll be your healthcare POA. What should happen then? What does that healthcare POA, that proxy, need to have or need to know?
So two things. First of all, when you're going to have the conversation about whether they're willing to do it, first of all, there needs to be a willingness to do it. And second of all, there needs to be an understanding between you and the person you're picking of what your wishes are, so that you know that if it's to, quote unquote, pull the plug, that they're going to be able to do that. I always like to say that medicine's not black and white, it's gray. So you're going to give direction and guidance in your power of attorney. At least that's what we do. We'll put language in there so they understand what you want. But the person who's picked has to be able to speak to the doctors or whoever the medical provider is and get all the information from them as to what they're saying, make a decision to determine whether or not your situation falls into the I'm ready not to do anything but have comfort measures only in hospice, or no, there's a chance of recovery and I want that. Because people want to have a quality of life oftentimes, and what is a good quality of life isn't the same for everybody. So you have to understand what it would be for you, and your agent understands that.
And if that document exists, does that healthcare POA, is that person expected to carry, say they are going to be making the hospital visit, the hospice, if that's what's going to happen, wherever they are, do they need to have that document, or is the onus, the responsibility on the principal, the person who's creating that document and wanting this wishes to be understood, is it their responsibility to give it to the doctor or give it to the hospital or upload it to Lifespan or whatever it is?
So when we do a plan for a client, one of the last things we ask is, do you want us to mail, and we will send original copies of your document to your primary care physician? Oftentimes with electronic medical records, and depending on what group they are, if you send it to your doctor, it's going to get uploaded to Lifespan or Care New England or whoever they're affiliated with, so it will be there. Many times when you check in, if you have to go to a hospital and you're there, they'll have those records when you go, if it's been put in through your primary care doctor. If not, they'll ask you for those. And if it's like a scheduled routine, I'm going in for some kind of procedure, when you're doing the pre-op, for instance, they'll ask you for those documents. So when we do a plan, we will have you sign 3 copies. One that we'll keep and scan in, and if you want, send to your primary care doctor. One that is to be kept in your binder that we give you, and one in the back of the binder to give to the agent if you feel they need it and they're ready to have it.
Okay, what's the duration of a healthcare power of attorney? Some have asked, is it up to the person's death, or is it extending months beyond, and why would that matter?
So that's an interesting question. In addition to the healthcare power of attorney and the living will, we'll also do a HIPAA release, which is a waiver of the medical confidentiality so that your agent can get your records. Technically, most powers of attorney terminate either when you terminate them or when you die. There are some where you can put in a language that you want it to extend for a month or 2 beyond your death. We also will put that into that HIPAA release so that if someone needs to get your medical records after you die, they're able to do it. So once you die, the power of attorney to make medical decisions obviously no longer has any import anyway.
Right. Yes.
So for it to extend beyond your death doesn't usually make a whole lot of sense. But if you need to get records, having that medical release that extends beyond your death is important.
Good to know. And another question came up. We automatically, and you automatically started to refer to when someone makes the decision to pull the plug, but apparently an agent has a responsibility to determine or help, I guess the word was implement actions that include whatever personal care is. And my question is, or the question is, what exactly does that mean? Is that the part that pertains to where someone might be living, a residential place, a nursing home? What does that mean? Or does it mean we're buying the toiletries from you? What does personal care entail?
Yeah, so it's interesting because usually medical decisions usually don't involve who you're going to live with or where you're going to live. But sometimes they can, because it could involve what kind of care you need and where you can get that. So that's what, it's sort of a gray area on exactly what that's going to mean. But if it relates to healthcare, bringing in visiting nurses or any of those kinds of things, then arguably that is absolutely covered by the healthcare power of attorney.
What about money? So you want your healthcare proxy to do as you wish. They want the best possible care, whatever that is, as long as that's viable. You, as that healthcare agent, you don't have their bank book. How does that get determined? I'd like them to have this kind of care and that kind of care. It's costly. Does their medical coverage cover it? Do they have their own personal resources to cover it? Where does that come in?
For whoever they appointed for their financial power of attorney.
So,
it can be the same person. Oftentimes it's not. And sometimes when you split those decision-making capabilities, there can be a bit of a conflict or disagreement between the person who's making the medical decisions and the person who's got the money to pay for it.
Say that again, David?
So the healthcare power of attorney limits you to making medical decisions. The financial power of attorney is the person in charge of the money and who's going to pay for those decisions. And so you could appoint the same person so that they have authority to access the money to pay for what you need. But if you appoint different people, they need to be on the same page.
So I'm hearing 2 silos. If it comes down to it, maybe you have time to contact someone else, but that number 1 assumes that the healthcare POA knows who the financial POA is, or health,
right.
who the financial power of attorney is. So what happens if there isn't that kind of time or isn't that communication? who's responsible for what? Would that healthcare proxy POA person end up being financially liable for having made a decision in what they thought was the best interest of that person, and then finds out that there's not coverage for it, insurance or personal resources?
No, the person who's making the medical decisions wouldn't sign. At least I would advise them not to sign anything personally, and therefore it's not their responsibility to pay for somebody else. But oftentimes, if it's a facility that someone's going into or whatever other in home or in place care is going to be given, there's going to be a financial paper, and they're going to ask who's signing this, who's responsible, how is this getting paid. So we always tell our clients that whoever they pick for agents, if it's not the same agent for a healthcare and power of attorney, make sure that they know who each other is.
So it's good for our viewers to be very aware of those two issues and how they relate. The issue of capacity or incapacity, who can actually decide? Is it always the doctor who decides or advises when someone does not have the capacity to communicate? And I don't mean speak, but communicate.
Right.
How does that get decided, and how does that play out?
In terms of medical decisions?
Yes.
So the doctor's going to almost always go to the patient first and try to get a decision. If it's the doctor's opinion the patient doesn't have the capacity to make a decision, that's when they're going to go to the agent.
And so when the physician on site is trying to get some decision, it doesn't have to be a voiced decision. Is that correct? Is it, so the bottom line question that was asked, if the person can't talk, they might be in that twilight place, almost coma, perhaps coma, but it's often said that people who are in a coma can sometimes still communicate by blinking an eye, squeezing your hand once for yes, twice for no, however that goes. Is that an acceptable form of communication to the doctor? And suppose he's willing or not willing to accept that? And when does that POA get to say, excuse me, doctor, I know when I need to take over here? How does that play out?
So usually the doctor will try to communicate with somebody. And if the doctor's satisfied that they are responding appropriately, even if it's not written, verbal, then they can accept that. If you're the power of attorney and you think that there isn't really good communication going on, it can be a very difficult conflict. And if it's in a hospital setting, they're going to send in more than one person perhaps to determine whether or not there is communication going on.
And if you are the POA and you want to do a responsible job, what happens if you feel on site that you aren't able to carry out your duties and responsibilities? Then what happens then? Does that person have to sign a legal release? Does that person what do they have to do?
So if the power of attorney has you appointed, for example, and you don't think you can carry out the duties, it usually will have the next person in line appointed, and so that person could just step in.
So you're saying that always you would advise that there be an alternate, a second person.
It can go as far as 3 or 4 if you want, but at least 2.
Okay. And when it comes to medication that is acceptable, pain meds, does that have an array of I'll take this but not that? Do you need to be that specific when you're playing out that document that says, here's what I'll take and not take? How much of a drill down do you have when you're putting that together?
It usually doesn't go that far.
Okay.
And if it's an allergy or that other kind of issue, your agent should actually have a conversation with you and know. It obviously should be in your medical records as well, but that doesn't usually go in.
What about consequences? What does the POA need to know about what kind of responsibility or consequences for their choices that there might be? Are they always absolved of any and all responsibility?
Well, when we write our healthcare powers of attorney or healthcare proxies, the language in it will spell out what the person executing it wants, the principal, and we say at the end of that, I hereby absolve my agent from any liability for following the things that I've laid out.
So I'm not familiar with, I haven't looked at it, but we always want to provide resources to people who might want to do some things on their own. And there's always some sort of rocketlawyer.com, and there are a couple of others, formprinter.com, legaltemplates.com or net. Would those things be that thorough from, as you say, selecting 1, 2, and 3 alternates, 4 alternates, down to the consequences? Are all of those things pretty typically covered, or are these things that only get fleshed out, those things that get fleshed out when they're sitting in front of a lawyer, you or otherwise?
Well, a couple of things. We like to go through all of these details and give all the interesting options and things that you need to think about. And I'm dealing with a case right now where they used an online form kind of thing for a will, and the fellow died, and we don't have an affidavit, or what we call a self-proving affidavit, so the will can get submitted to probate and be approved. And the witness who signed them would now have to come into court to prove the will for probate, but they can't find the witnesses, so it's almost useless. And so I'm always concerned when you do things on your own. And even if this will had been done correctly, it doesn't have power to sell, and we need to sell real estate. So when you don't do things with a lawyer, oftentimes to save $1, you're going to cost yourself a lot more. Powers of attorney for healthcare, there are other things that we would want people to consider that we put into them. For example, are you an organ donor? And so if you are, we'd like to put that language right in so your agent knows you're an organ donor. So there's not a question when we come to the end of life, oh, is this person an organ donor? I don't know, I don't have their driver's license, because sometimes that has the heart on it. But it's right in the power of attorney, we know. And we say, yes, I'm an organ donor to save a life. Maybe not for scientific research or anything like that, but this is what I'm willing to do. Where do you want to be buried if you die? Do you want to be cremated? Those kinds of things. Those are some things that we dive into a little deeper than if you're just filling out the form.
Good to know. And what about, back to the residence issue, long-term care, short-term care, is that part of a health care POA also? I mean, it has financial consequences for certain, so does that health care POA get involved with that at all?
To the extent that it's a medical decision, perhaps.
Okay.
But we do cover that in the financial power of attorney.
So it was interesting in reading the various questions that have come up. Many had said that there are issues, limitations with living wills or healthcare power of attorneys, or lasting, what is it called? Lasting POA, durable POA. And one of the issues that came up is that when people do it on their own, that they have either unclear language or some sort of insufficient instructions even for the person who they've selected as their healthcare POA. Is that, in your mind, as a lawyer, the single biggest difference in whether or not they have a strong document doing it themselves versus being with you? Is that where you make the cutting edge difference?
Well, that is one of them. And there's certainly, for example, in financial powers of attorney language that says, this is a durable power of attorney. It's not affected by time, and my subsequent disability doesn't affect it, meaning if I become incompetent. So oftentimes that's why we're doing those powers of attorney, so they're there when I do become incompetent. And banks oftentimes will say, well, this was done like 8 years ago. We need it up to, no, it says time doesn't affect it. So they should be forced to accept it. Powers of attorney for healthcare, it's less of an issue because the doctors just want to know you have authority, but it's good to have certain kinds of language in there that there's no question about what your authority is.
I mean, I think most people would understand that attorneys are likely to know what the best practices on all of these fronts would be, but you know, these nuances that come up as questions. Oh, so another question was, does everyone have to have both a living will and a healthcare POA? Is that a state-by-state thing? And the other part of that was, what happens, is there ever an occasion when those two documents could be in conflict, David?
Yeah, so not usually. If they're drafted correctly, they won't be in conflict.
Okay.
But they do serve different purposes. So the living will is to me, primarily if you're in a hospital and a doctor has to make a decision and the healthcare power of attorney can't be reached, it's one of those DNR kind of situations. So when you go into the hospital and you have a living will, they will actually probably put right on your record, DNR. And so they have that information. The power of attorney for healthcare agent is going to make decisions when it's not clear what is the right answer and someone needs to weigh in.
And again, I guess this speaks to a question that arises if not all of the documents are properly done. At times, if someone gets older, some family member decides, I need to be that person's guardian. What happens to all of those documents that had been put in place if someone suddenly says, I'm going to pursue becoming a guardian, gets a lawyer, has that done? Now what happens?
These documents are put in place to avoid a guardianship. And in fact, when someone applies for the guardianship, they're asked on that form, have these alternatives been explored? And so it's possible the court will turn down a request for a guardianship if those documents are in place and valid. So if you have them, you may avoid having to have a guardianship. But if guardianship will terminate someone's authority under the documents.
That's an important point.
Yep.
That is an important point. What does the expression to indemnify and hold harmless at the person's expense any third party who accepts and acts under this healthcare POA, what does that actually mean, David?
What that means is that if a doctor, for example, listens to the agent, there can't be a lawsuit against them for following that agent's recommendations or advice. They have to listen, and if they do, they're excused from liability for listening.
For listening.
For following the request.
And so again, are there any expenses or consequences that someone needs to know about when they're signing or not signing some of these documents? You don't have to sign that you're a POA, right? The healthcare POA.
You have to show the POA.
Have to show it. So are there any expenses to be incurred that someone would not anticipate if your brother-in-law mentioned you're going to be, or your sister-in-law mentioned you're going to be my healthcare proxy? Is there anything that needs to
No, because a healthcare proxy isn't taking any financial responsibility.
None.
They're just listening to the information from the doctors and making a medical decision.
And is there a definition of what die naturally means?
Dying naturally?
Yes.
I would say dying naturally means that you die of natural causes and that nothing has caused your death.
And that doesn't mean that it precludes pain meds.
Yeah, so pain meds, and we put this in our documents for comfort measures only, even though they may shorten your life, aren't the cause of the death theoretically. But if they are and you die 10 seconds earlier or a minute earlier or 10 minutes earlier, that was expressed in your document that that's what you wanted to be done.
Thank you for that deep dive. We hope that this has been helpful to you in deciding how you might want to handle your affairs. As we say, stay tuned to The Law Matters. It matters to you. Thank you for tuning in.